what are the aspects of Illinois law in the medical malpractice context? Well, there's a couple of areas in Illinois that address this. Number one is the percentage, the contingency fee contract can only be 30% by statute. So there's a cap on that. So a lawyer can never charge more than a 30% contingency fee in a malpractice case. Number two is Illinois requires that the lawyer provide an affidavit with the court when we file a complaint in the case, saying that we have an opinion of a qualified expert in the same area of practice as the medical provider that we're going against. For instance, you need a doctor for a doctor, a nurse for a nurse, but you also need a cardiologist for a cardiologist. You should have a cardiologist talking about an ER doctor, and so that's a requirement. And then as you go through in litigation, but those are the really only hoops to jump through. Now you have a legal in terms of statutes, but you have a lot of other to win a malpractice case. The plaintiff always has to go through all the hoops. If they ever miss a hoop, they lose the case. So the burden of proof is always on the plaintiff to prove the case. The other requirements that you have that are similar to all other litigation is you're going to do discovery, you're going to do questions, you're going to take depositions, but then you're going to have your experts. So you're going to identify your experts, you're going to provide reports. The other side's going to depose them. You're going to depose their experts. I did it last week. I'm doing it right now in a lot of cases. And so you're going to have your experts. And a lot of times malpractice cases end up being battles among experts because it's these nurses or these doctors or these folks who are in the field that are able to opine and talk about that. We also look at medical treatises and medical articles. There are other states with other tort reform that makes it harder. States bordering Illinois, for instance, Iowa and Missouri have tort reform. Iowa has a closer statute of limitations, which reminds me, in Illinois, it's 2-year statute of limitations to file a lawsuit for medical malpractice. It can't be extended. If you're a minor, if the injury happens to a child or someone under the age of majority, that statute is tolled or stopped until that child is 18, and then the clock starts ticking again. So generally, by about age 20, you have to file a medical malpractice claim for a child. Other states have caps on economic damages, other stuff like that. Illinois doesn't. The other thing about Illinois, one last point before I end this video, is that if the injury results in death in Illinois, it becomes a wrongful death medical malpractice case. And in that case, the wrongful death damages are pretty broad in Illinois with great jury instructions on that. You do get grief and bereavement. You also get loss of companionship, loss of consortium. You get future wage loss if the deceased is supporting people. You get economic damages. You get the pain and suffering the person went through between the time of the injury and the death, if that is demonstrable. So there's a whole host of damages. I know this video only hits the tip of the iceberg on the legal aspects of medical malpractice law in Illinois, but I want to do a quick video on some of the major components of it. If you're faced with a medical malpractice claim in Illinois and you're trying to navigate this, a couple of things. You got 2 years to file, but you ought to get to a lawyer like me, like Gary Berger at Berger Law, or if there's other great lawyers out there. You ought to get to us right away to look at the case and analyze it, because I can't look at a case fairly right before the statute's going to run at 1 year and 11 months. I just don't have time. I got to get medical records. I got to talk to experts. I got to talk to witnesses. I got to weigh these important issues, and then it's not only the negligence, the breach, or the deviation of the standard of care in the first instance. It's also causation. You got to prove that the negligent caused the injury. And so that's something you should be cognizant of. If you have any questions about that, go to burgerlaw.com. We have a lot of information on medical malpractice. Thank you.